Welcome, you curious learners, to a deep dive into one of the most talked about, truly controversial legal sagas of our time, the Jeffrey Epstein and Ghislaine Maxwell scandal.
And here we are, end of July 2025, and the secrecy around the Epstein files. It's still causing huge debate.
Huge. It's challenging public trust, shaking up Washington. You hear a lot of people, especially, on the political right, demanding full transparency.
They believe powerful figures are still being shielded.
Right. And remember those promises about releasing a client list? Well, now the Justice Department says, actually, no such list exists.
Which just fuels more suspicion, doesn't it? That maybe there's a deeper cover-up.
Exactly. And then you have the Trump administration trying to get grand jury transcripts unsealed, but hitting roadblocks with judges.
Leading some to ask, is the quote-unquote deep state blocking things, especially after reports that Trump's own name showed up in the files.
It really makes you wonder, what is still hidden, and why is it so incredibly hard to get everything out in the open?
So today, we're not just running through the timeline again. Our mission is really to pull back the curtain.
Yeah, look at the fight for transparency, get into this complex world of grand jury secrecy, and untangle the political drama that's still swirling around.
We've looked at AP reports, legal explainers, political analysis, trying to piece it all together for you.
We want to boil down the key facts, connect the dots between the legal stuff and why everyone cares so much, give you a solid understanding of why these files are still such a hot topic.
Think of it as your shortcut to getting up to speed on a story that honestly just keeps twisting and turning.
Okay, so let's unpack this right from the start, because the groundwork for this whole thing was laid way back March 2005.
That's right, Palm Beach, Florida. Police start investigating Epstein after a 14-year-old girl's family reports she was molested at his mansion.
And then more underage girls came forward, said they were hired for, sexual massages.
And here's the first, let's say, really controversial point. By May 2006, the police were ready. They had charges prepared, multiple counts of unlawful sex with a minor.
But then the county's top prosecutor, State Attorney Barry Krischer, did something pretty unusual.
Highly unusual. Instead of filing charges directly, he sent the case to a grand jury.
Which then, July 2006, comes back with just one indictment, a single count of soliciting prostitution, a relatively minor charge.
And that immediately drew criticism, even from the police, who felt Krischer gave Epstein special treatment.
It was a huge moment, wasn't it? It kind of set this pattern, suggesting maybe the powerful play by different rules in the justice system.
Precisely. It wasn't just a light sentence waiting down the road. It signaled something deeper about access and influence. It sowed seeds of distrust we're still dealing with.
And then get this, in 2007, federal prosecutors were actually gearing up to indict Epstein themselves.
They were. But for a whole year, Epstein's lawyers were negotiating behind closed doors with the U.S. attorney in Miami at the time, Alexander Acosta.
A secret plea bargain.
A secret arrangement, exactly. And it let Epstein completely dodge federal prosecution.
So he ends up pleading guilty in June 2008, but only to state charges. Soliciting prostitution, one count involving a minor.
And the sentence. Just 18 months in jail. And most of that time, he was on work release, leaving jail during the day.
A deal that lenient, that secret? It's no wonder people were outraged. It just felt wrong.
Absolutely. And the victims didn't give up. After Epstein got out in July 2009, for the next 10 years, women like Virginia Gravy fought in court.
Trying to undo that federal non-prosecution agreement, the MPA.
Exactly. Jeffrey's lawsuits were explosive. She claimed Epstein and Ghislaine Maxwell set up sexual encounters with, a whole list of big names: royalty, politicians, academics, businessmen.
Like Prince Andrew, starting when Javrov was only 17.
Right. Now, it's crucial to say those men all deny the allegations, but the lawsuits kept the pressure on.
Which brings us to the next phase: renewed charges, Epstein's death, Maxwell's conviction. Things really escalated again.
A huge catalyst was the Miami Herald. Their series in November 2018 really focused on Acosta's role in that original deal.
And that just reignited public interest big time.
The pressure became intense. And it led directly to Epstein being arrested again, July 6, 2019. This time, federal sex trafficking charges in New York.
And the New York prosecutors, they made it clear.
Very clear. They said they weren't bound by that old Florida MPA.
And just days after Epstein's arrest, Alexander Acosta, who was then Labor Secretary,
he resigned. The public anger over his handling of the original case was just too much.
Then the story takes another dark turn. August 10th, 2019, Epstein's found dead in his jail cell.
Investigators ruled it a suicide. But as you can imagine, that just added fuel to the fire of questions and conspiracy theories.
Yeah, a lot of questions still linger around that.
So with Epstein gone, the focus shifted. July 2, 2020, federal prosecutors in New York charged Ghislaine Maxwell.
Alleging she helped recruit girls, sometimes even participated in the abuse.
There was a month-long trial. And on December 30, 2021, the jury came back. Guilty. Multiple charges, sex trafficking, conspiracy.
And her sentence came down in June 2022.
20 years in prison for helping Epstein abuse those underage girls. You might remember seeing Sarah Ransom, one of the alleged victims, speaking outside the court that day. Really powerful moment.
So that's the shocking timeline. But to really get why these files are still causing such a firestorm, we need to dig into something often hidden from view, the grand jury.
Right, because that's where so much of the secrecy and the controversy really starts.
Okay, so break it down for us. What exactly is a grand jury? What kind of power are we talking about?
It's a fundamental part of this system, but yeah, often misunderstood. A grand jury is basically a group of citizens empowered to investigate potential crimes and decide if there's enough evidence to bring formal charges, which are called indictments.
And they have real teeth.
Oh yeah. They can subpoena evidence, force witnesses to testify under oath. In the federal system, it's usually 16 to 23 people, and you typically need 12 votes to indict.
And you mentioned it has two roles.
That's right. It's seen as both a sword to accuse people who likely committed crimes and a shield, meant to protect citizens from unfair or baseless prosecution by the government.
Okay, the shield part, that sounds good. But if it's meant to protect, why operate in total secrecy? To a lot of listeners, that sounds like, well, a perfect recipe for hiding things.
And you've hit the absolute core tension right there. There are traditional reasons for the secrecy, and they have some logic behind them.
Like what?
Well, one, to stop suspects from running away if they know they're about to be indicted. Two, to protect witnesses and the jurors themselves from being threatened or influenced.
Okay, safety makes sense.
Three, the idea is that secrecy encourages witnesses to testify more freely and lets jurors debate openly without outside pressure. Four, it protects the reputations of people who get investigated but are ultimately cleared, not indicted.
Right, so your name isn't dragged through the mud unfairly.
Exactly. And finally, the worry is that if everything was public, it might have a chilling effect, discourage future witnesses from ever coming forward in other sensitive cases.
Okay, I can see the arguments for it, protecting the process. But the critics, especially in a case like Epstein's, they argue this secrecy has a massive downside.
Absolutely. The biggest criticism, lack of public oversight. When it all happens behind closed doors, how can the public be sure the process is fair? How do we know prosecutors aren't abusing their power or, shaping the narrative?
And what we do here is often filtered?
Often, yes. Through prosecutors or court orders, it might not be the whole picture.
Yeah.
Think of the rule governing this, Federal Rule of Criminal Procedure 6. It's like a legal vault.
Hard to open.
Extremely hard. There's a very long legal history favoring secrecy. And another key point, the person being investigated. They usually have no right to even be there, no right to argue their side or present evidence that might clear them during the grand jury phase itself.
Wow, so it's really stacked in favor of the prosecution at that stage.
From the perspective of the process itself, yes, largely.
Which brings us right back to the present, 2025, and this whole Epstein files controversy. The push for transparency is intense, particularly from the political right, from the Trump administration.
A huge amount of public interest focused on finding out who was in Epstein's network.
Yeah.
The rich and powerful men.
And it really zeroed in on this idea of a specific client list.
Right. You had figures like Kash Patel in January 2025 vowing to expose connections. Then, February, Attorney General Pam Bondi goes on Fox News.
I remember that. Said the client list was sitting on my desk right now, claimed it was a directive by President Trump.
That really set expectations sky high.
Then came the Phase 1 binders incident, end of February 2025. Bondi hands out these binders at a White House event. The Epstein files, Phase 1.
But they contained very little new information, which understandably frustrated a lot of conservatives who were expecting major revelations.
And the saga continued. July 2025, the DOJ and FBI put out a memo
stating flatly, there is no client list and also no evidence of foul play in Epstein's death.
which for some Trump supporters just sounded like proof of a cover-up.
Yeah. It's important to note, though, that what many people really wanted wasn't just a list of names, but the underlying evidence, witness statements, financial records, flight logs, the things that would show the extent of the network.
So amidst all this, the Trump administration made very public moves to try and unseal grand jury testimony, right? Citing abundant public interest.
They did petition the courts. However, the DOJ itself revealed something crucial in July 2025.
What was that?
They stated that the actual grand jury transcripts related to Epstein, they only contained testimony from one FBI agent and from Maxwell, the same agent, plus an NYPD detective.
So no victims testified directly in those grand jury proceedings?
Well, not in those specific ones, according to the DOJ, which means those transcripts are probably unlikely to reveal new names of other potential perpetrators, which is what many people are hoping for.
And the courts pushed back anyway.
They did. On July 30th, Judge Robin Rosenberg in Florida, an Obama appointee, which gets mentioned a lot, denied the DOJ's request to unseal the 2005 and 2007 Florida grand jury materials.
Why?
She said the request just didn't meet the very narrow legal exceptions required to pierce grand jury secrecy. The DOJ is trying in New York, too, with Judges Berman and Engelmeyer.
It feels like a legal catch-22 sometimes.
Well, and some critics suggested the administration knew these requests would likely fail.
Like it was political theater.
The argument from some, like on Reddit threads, was that it was maybe a setup or a distraction, make a public show of trying, knowing that judges would likely say no because the legal bar is so high, and then blame the judges.
Allows them to say, we tried.
Potentially. It highlights the political maneuvering layered onto the legal process.
And speaking of politics, President Trump's own language on this shifted quite a bit, didn't it?
It really did. Before May 2025, he'd talk about releasing files, but add qualifiers concerns about third parties, phony stuff.
But then came that Wall Street Journal report in May, claiming Bondi and Deputy AG Todd Blanche told Trump his name appeared multiple times in the Epstein files.
And after that report, his rhetoric seemed to change. Became much more abrupt, sort of a move along, nothing to see here vibe.
And he started hitting back hard.
Oh, yes. July 2025, he's calling media focus a desecration, calling the case pretty boring stuff, saying the whole controversy was a hoax invented by radical left Democrats.
There was also that alleged racy letter to Epstein reported by the Journal,
which Trump called fake and immediately sued the Journal for, $20 billion on July 18th.
And the administration confirmed no special prosecutor for Epstein.
Correct. Caroline Leavitt said Trump wouldn't recommend one. Then, just days later, Trump was urging his DOJ to investigate former President Obama over some unrelated alleged scheme while saying he didn't follow it too much regarding Epstein.
It's been a real roller coaster of statements and actions. But Democrats were pushing back too, right?
They were. Also, on July 30th, Chuck Schumer and Senate Democrats used a pretty obscure tool called the Rule of Five.
Never heard of it.
Hardly anyone has.
Yeah.
It basically allows 5 members of certain committees to demand information from government departments. They invoked it specifically to try and force the release of Epstein files from the DOJ. A direct challenge.
Wow. Okay, so while all that is happening, Ghislaine Maxwell is fighting her conviction.
She is. Her appeal landed fully briefed before the Supreme Court, actually just yesterday, July 31st.
What's her main argument?
It all goes back to that 2007 non-prosecution agreement, the NPA, that Epstein got in Florida.
The one negotiated by Acosta.
That's the one. Her lawyers argue that the Southern District of New York prosecutors who charged her unlawfully ignored that Florida NPA.
How so?
Because the NPA language protected not just Epstein, but also potential co-conspirators. And crucially, it referred to the United States making the deal, not just this district, meaning Florida.
Ah, so she's saying the United States means the entire federal government, including New York prosecutors, should have been bound by that Florida deal.
That's exactly her argument, that the deal Epstein cut should have shielded her too, everywhere.
Is that a strong legal argument?
Well, it hinges on something called a circuit split, which means different federal appeals courts across the country disagree on this exact issue.
How do they disagree?
Maxwell's appeals court, the Second Circuit in New York, said NPAs like this only bind the specific district that made them unless they explicitly say otherwise.
Yeah.
But other circuits, the 3rd, 4th, 8th, 9th, have ruled that using the United States generally binds the whole federal government unless it's specifically limited.
So different rules depending on where you are. That seems messy.
It is. And Maxwell's hoping the Supreme Court will take the case to resolve this split in her favor. It's a real legal long shot, but it exploits this inconsistency in how courts read these agreements.
What does the Justice Department say?
The Solicitor General, D. John Sauer, is urging the Supreme Court not to take the case.
Why not?
They argue her case is too specific, too fact-bound, and wouldn't neatly resolve the broader circuit split. They also point out that having a co-conspirator clause like this in an NPA is pretty unusual itself.
And the Supreme Court, they don't take many cases.
Very few, percentage-wise. They look for clean legal questions where there's a clear disagreement among lower courts that needs fixing. We'll likely find out if they'll even hear her appeal sometime in October 2025.
But there's one more potential twist, isn't there? A pardon.
The elephant in the room. If President Trump were to pardon Ghislaine Maxwell, her whole Supreme Court appeal just disappears. It becomes legally irrelevant or moot.
Which would end that legal fight instantly. Adds another layer of unpredictability.
It really does. It shows just how much the legal track and the political track can influence each other in these high-profile situations.
So we've walked through this incredibly complex maze, the legal battles, the political plays, this constant push-pull over secrets and transparency surrounding Epstein and Maxwell.
And what becomes really clear, I think, is that chasing transparency in cases like this, involving powerful people and secret processes like grand juries, it tells us as much about our legal system, our politics, as it does about the actual crimes.
That tension between needing secrecy for investigations versus the public's absolute demand for truth, it's a huge challenge.
A profound one, especially right now when public trust in institutions feels pretty shaky for a lot of people.
So it really leaves a question for you, the listener. How do we strike that balance between the traditional need for grand jury secrecy, which has its reasons, and the public's fundamental right to know, particularly when the stakes feel this high?
Because for many people following the Epstein and Maxwell cases, real accountability isn't just seeing someone convicted. It's about understanding the whole network, the influences, pulling back all the curtains.
So as we wrap up this deep dive, maybe think about this. In our world of nonstop information, where do you personally draw the line? What's necessary confidentiality and what's essential transparency? And looking at this case, what concrete steps do you think could actually help resolve these lingering questions and maybe, just maybe, restore some trust?
Definitely something to chew on.
There's nothing to mull over until our next deep dive.